Good afternoon, everyone, and welcome to this joint committee session of the Government Operations and Fiscal Policy and the Public Safety Committees. We have two items on our agenda this morning. First is an amendment we received to the FY27 to 32 Capital Improvement Program, the county radio life cycle replacement that we will discuss first, and then we will move on to expedited bill 14-26, motor vehicle towing, redemption of vehicle. Ms. Farag, should I turn over you or Dr. Torregas? Oh, actually, my co-chair, would you like to say a few words before I do that?
No, I think you can turn it over to either one of those two staff members, please.
All right, great. Let's deal with this amendment first.
Thank you very much. This is a March 13th County Executive Amendment to the FY27 through 32 Capital Improvements Program for the County Radio Replacement Project, which has already been reviewed by the Joint Committee, or the original submission was. This amendment is actually reducing expenditures by $2.6 million, and it's spreading the expenditures out, so it's delaying some replacements. It's spreading it out across the entire 6-year expenditure schedule. The reason for the reduction is there were duplicate entries for 55 police radio replacements in both FY27 and FY28. So the new expenditure schedule is removing the 55 replacements for FY28, and council staff recommends approval as submitted.
Perfect. Councilmember Katz, any questions?
I'm good.
All right, anyone else have any questions or anything? No, I think the joint committees are good with the recommendation and moving forward with this.
Thank you.
All right, thank you very much. Our next item is expedited bill 14-26, motor vehicle towing. This is also known as the Vehicle Recovery Act. I see Ms. McCartney Green is here, and we have Dr. Stoddard from the County Exec's Office. Thank you for joining us. As the lead on this bill, I will say that, and I'm thankful to all my colleagues who have joined on as co-sponsors. This grew out of conversations with community members, members of our nonprofit organization and mutual aid groups. And I'm thankful that We Are CASA is here today as we're discussing this bill. And also conversations I had with the police department in the city of Tacoma Park. As we saw an increase in federal immigration activities in the county, we saw people being taken off our streets and their vehicles being left behind. And in some instances, reports of ICE not just leaving vehicles, but blocking hydrants, fire stations, and putting them in places that the vehicles needed to be towed immediately, leaving no time for family or friends to recover them after someone was taken. And then what happens is once the vehicle is impounded, there are obstacles to recovering that if someone is not on the title, nor if they did not have a notarized document saying that they were able to have the vehicle released to them. And so after hearing many of these stories and looking at how we can assist those who are being impacted by having loved ones taken from our streets, we looked at drafting this legislation and what alternative forms of identification would be available to have documents released to people who had a familial or household relationship. Basically, we were looking at what could be a plan C. So if people were not already on the title for ownership or did not have the notarized document, how could they get a much needed asset for their family, their car, out of impoundment as quickly as possible? And so that is where we are here. And I'll see if my co-chair have anything to say? No?
We're good.
All right, Ms. McCartney Green, do you want to walk us through the packet and any discussion of any items?
Thank you, Madam Chair Stewart. As a matter of fact, you did a good job walking us through some of the preliminaries. I'll just circle back on a few specific things. So the bill is really standardized or codifying existing regulations that are under the executive regulations for police tow, specifically when it comes to release of a vehicle. And so if a vehicle is going to be released, one of the things is if there's an owner that's present to pick up the vehicle, they're required to have a government issued identification along with proof of the motor vehicle registration. So the bill is codifying that part. It's also saying that if the owner is unavailable or not there, that they're able to authorize an agent who they give permission to either via a notarized letter or my permanent preferred terminology is a power of attorney. That's some of the documents that you can use to be able to give permission. The regulation also mentions that where there's a documentation from an insurance company, lien holder, or a rental company as well. And as you mentioned, the purpose of this legislation is to actually broaden that to be able to accommodate for when there's not a letter available and the owner's not available as well, that a family or a household member may have the option to redeem the vehicle. Some of the requirements that are needed is that they're allowed to show a U.S. or state government ID, foreign government ID, or a valid ID from a nonprofit organization, along with one other document showing shared residence to the title of where that vehicle is. And that's using utility bill, deed, mortgage statement, lease agreement, marriage certificate, or birth certificate. For the RESJ statement, we received a positive impact from on the Office of Legislative Services. No other impact concerning fiscal impact or climate assessment. The purpose of the bill is to provide a mechanism, basically, and to make sure we can do that while also maintaining appropriate safeguards. With that being said, I don't know if MCPD is here to be able to give an overview, but if not, I'm happy to at least mention generally that state law provides under Article 25 the authority when it comes to certain aspects for vehicle removal. It sets a framework, but it's not occupying that entire field. So the county does have authority to be able to regulate towing, parking, impoundment. When it comes specifically to release of a vehicle, one of the things that if there's a vehicle that's abandoned, it requires release to an owner or an authorized agent. In this case, the state law doesn't really define what documents are needed to reclaim, and hence why we've expanded that here. So that kind of discusses a little bit about the general process. I do want to turn to the packet on page 5, number 2, unless there are questions that the committee had. Turn to the packet on page 5, number 2, the consideration of additional documentation to support proof of shared residency. The reason why council staff highlighted that because there was testimony that we received from CASA concerning recommendations to broaden the bill to include additional documents. And some of the things that were mentioned were school ID that was provided by the Montgomery County Public Schools, or tax returns, or other correspondence. Council staff did look at this and kind of went through and wanted to kind of explain to the committee, made a recommendation that I was a little bit concerned if we had broadened it too far. And the reason why it's important to understand that is because when the police tows a vehicle, it's non-consensual. They weren't given consent to tow that vehicle. And the vehicle it's a property interest for the owner. So what that does is it triggers a legal framework, and I didn't get that too deep here, but the reason why it's important to understand the legal framework is because the owner has we use the term prima facie, or the ultimate authority. This bill gives the authority for a non-owner who may not have the absolute permission. And so when we think about lowering the threshold for documents that could be included, we want to be careful that we're not too far lowering the bar where it may be a little bit negligent in terms of, are we looking at documents that could be redacted? So that was one of the things with the IRS tax returns. Like, it is a valid document, but the issue is that providing a document with PII information, personal identified information, or a document that's used to show earnings, whatever, probably is not the best practice for a towing company to be able to use to verify. And so there were concerns there. There's a risk management part of this bill. We don't want to release the vehicle to the wrong person. And so in balancing that, council staff was concerned that not to allow too many alternative documents that could be redacted, or too many documents that would not be able to be verifiable. And so right now what's in the bill is a birth certificate, a deed, a lease agreement. And some of those documents are third-party verifiable documents. And so it was broadening the scope, but not weakening it too far out. I also looked at other jurisdictions. Hey, what are they doing? Are there other? Montgomery County is a leader in this in terms of other counties. Baltimore County, Baltimore City, Howard County just requires an ID and the registration, they don't allow for alternative documents. So the fact that we are stepping out, I presume, Councilmember Stewart, that's a good slate, but we didn't want to step too far where a non-owner would show less documents than an owner would in some of these circumstances. So that's a long story to say that was council's staff review of that, and did not recommend to include those documents in the bill.
Appreciate that overview, I think, and also very much appreciate We Are CASA's input and collaboration on working on this, because I think we all share the same goal of reuniting families and individuals with the vehicles. And in this case, because we are talking about property, there is, balancing that. So I appreciate that work to do that. And I'll see if my colleagues have any questions. Councilmember Lukey?
So thank you, Ms. McCartney Green, and for going through things in great detail. And one of the things that I think sometimes folks who've heard about the bill or whatever, they're conflating or they're misunderstanding a couple things here, right? The point of the bill is to do something really practical, which is to deal with the problem that folks are facing right here, right now, to make sure that someone can pick up their vehicle, right? But if the person who is picking up the vehicle, who is the person authorized to do so in the notarized document, may not be a licensed driver, but someone who is a licensed driver, who might not be the person named in the document, can be with them and can drive the car. And so there's nothing in here at all in what we've proposed that changes that at all. It's just a way to facilitate folks being able to get their property back, their family to get their property back, and whoever ultimately drives the vehicle off the tow lot has to have a valid driver's license. I just wanted to confirm that was true.
That's correct.
Yeah. Okay, great. Just wanted to make that clear for everybody.
Thank you. Councilmember Katz?
Thank you, Madam Chair. My question is, if a vehicle is towed from Montgomery County, but the tow yard is in Prince George's County, how would this bill work?
It's a good question. From my understanding of the reading of the law is that you have to be towed within a certain amount of miles from where they.
You actually have people behind you shaking their head. You want to come forward, please? We have a tow expert here.
Good afternoon. I'm Sean Carew, Operations Administrator with the Office of Consumer Protection. Do you want to introduce yourself? All right, go ahead.
Lorena Bailey, Investigator, Office of Consumer Protection.
So currently, a car can be towed 15 miles from the point of origin. Mm-hmm. There are very limited tow lots in Montgomery County, and there are even fewer that are within that 15-mile distance across county lines.
So could there be an addition to this, knowing that this could happen? I mean, if you're in Tacoma Park, it could end up. Could we have something that says that if it's towed from Montgomery County, that this law, since they took it from Montgomery County, that this law would be in effect?
So I think maybe one of the things that our office was most concerned about, that's the private property trespass towing law. So for police, I don't know that they have the same 15-mile designation as Consumer Protection does for trespass towing. So I don't know how to answer that for the police tow law. There's like a real clear, like, first of all, I want to say like towing is the number 3 complaint category in our office from private property. So it was a big concern, and we thought this was great, and we hope that one day it does apply to private property towing as well. But yeah, as for a police tow, I don't know the limitation of how far they can tow it out of Montgomery County.
Okay. It's just something to be another wrinkle in this whole thing.
Dr. Stoddard, do you want to
Another
chime
tow
in?
expert. We're going to hear from another tow expert.
Yeah, I've been confused as being an expert in many things. I am absolutely not a tow expert. My understanding is that when Montgomery County Police Department directs a towing by a company, it will end up in their lot temporarily, but is transferred to our vehicle lot soon thereafter, and then that's when the notifications are made by the police department and others to effectuate the state law. So it does end up in our controlled lot
Okay,
if directed by the police department.
good. That answers my question. Thank you.
Yeah. And not to go out and lit, but I believe, and Dr. Fowler, you can confirm that most of the cases that I'm talking about are cases where, because the vehicles are in a place that need to be removed quickly, the cases we're talking about here are things that are being removed by.
Yeah, these are typically in the right of way.
Yes.
They've been left on the side of the road. We've had, there are very infamous cases in Minnesota where they were left in drive in a roadway, and so obviously these are towed principally as a combination of life and safety risk because they're left unattended in places like that, but they're also towed because they may be blocking entrances to any number of different, they're on public right away, but they're blocking all kinds of things. If they're left in a spot, they're often, it may be some time before they are towed because of, we don't necessarily always tow something immediately if there's no reason to do it and allow someone to potentially come pick up the vehicle who might be able to. But if it's in the right of way, if it's blocking fire hydrant or blocking other public amenities, then it's going to be towed.
Right. And I think the instances that we've heard from residents is because they're not parking it like in a parking spot or on a parking lot of like the Aldi's shop, or there's no time for family members or others to retrieve the car. And so we are talking about something where things are happening pretty quickly.
And there obviously are circumstances when windows are broken to effectuate the detentions, and those are also situations where if we see a public hazard like that with vehicle with broken windows, that they'll often will tow in those circumstances as well.
Thank you. Does that answer your question? Yeah. Great. Councilmember Mink.
Great. First, thank you to the chair and to her team for the thoughtful work on this and for the work directly with community members who are really in the thick of it and seeing a lot of these cases. It's great to see that informing legislation that I know we're going to get done here in Montgomery County. I've seen a number of cases where the person who was taken might not have any other family members here. They were the only family member in the area. They've been, sending money to support their family elsewhere sometimes, and that's been posed some serious difficulties to getting vehicles back. You cannot get a letter signed by them at that point. It's hard to even find where they are often, and in many cases, they are living with, in a shared house with other folks who are in the same situation, but they're not family. And so ensuring that there is a channel here for a shared household member to be able to retrieve that car, that vehicle for that person is really a big deal. And I hope that we see this emulated in other places because it really is unfortunately necessary at this point. Another common situation is where the person who's going to go pick up the car often, the person who might be a family member who has maybe citizenship, and they're the person who is comfortable to go and get the vehicle and drive the vehicle home. That might not be a spouse. It might not be a child. It might be an in-law. It might be, right, it might not be somebody who is kind of the first person you would think of when you think familial relationship. So I wanted to check where it says familial relationship. Could that mean, for example, an in-law? Like, what does that mean in terms of the law? I know that we have here, they could use a birth certificate, they could use a marriage certificate. Could you use like a combination of those? What kind of flexibility is there to account for situations where it could be a cousin-in-law, that sort of thing?
So because of the various dynamics of a household, it's very, very fluid of what a household consists of.
Well, let's say they don't live in the same residence though. They don't have a shared address, but they are family, but not immediate family.
The title of the vehicle is what we're talking about. If someone's going to be able to pick up the vehicle, the connection is that they have the same title address as the vehicle. And so it could be a shared residence. It could be a familial relationship. I think the more important part is that the vehicle that they're picking up matches the document that they have, and that address is what we're linking as them being some type of authorized agent. And so if that individual lives in the home but does not have something that's tied to that address, it makes the burden even harder for them to say, we are presumed we're thinking about lawful possession, right? And how to show control. It is hard to show control if they don't have an address that matches the vehicle address that's registered with the Motor Vehicle Administration.
Okay, so where it says that they have to have at least one documentation reasonably establishing shared residence or familial relationship, does that?
And the only reason why I was there, Councilmember Mick, is because birth certificate is there, right? So if there's a parent or a child situation, that was one of the reasons. So the option here was to make it broad, not to narrow it, and to give that flexibility.
I'm just trying to understand. So if there's a family member who wants to retrieve the vehicle, does their address matter, or only if they can prove that they are a family member?
It could. So for subsection A, those are relatable address. So the utility bill, the service bill, that's where. For B or C, that talks more about the familiar relationship, whether the birth certificate could show. So in this circumstance, when we say familial, it'd be the marriage or the birth certificate to show that close relationship. Or if there's a cousin that lives there, maybe the address that's on the utility.
Okay, here's where I'm confused, because I'm trying to distinguish between whether, let's say that it's a cousin. Okay, let's say that it's a child, an adult child, but they don't live in the same residence. That would work, right?
Correct,
Okay.
they use the birth certificate.
Okay. What if it is a cousin or a brother-in-law? They don't live in the same residence, but they can prove that they are part of the family because, let's say it's a brother-in-law, right? You can prove that you can prove the marriage, you can prove the sibling relationship. Now you've proved that you're in-laws with that. So you've proved that you have a familial relationship. Would that work?
That chain of custody is harder to prove. When I say chain of custody, from the owner to who may be the uncle or cousin, that is harder. And I said the burden there really weakens the threshold. And this all goes back to the fact that the vehicle is a property interest, and we don't want to deprive the owner of that property interest by saying two next of kin was able to retrieve it, but we didn't have something to support that. So that's my concern there.
My only concern about that is the operational elements of it. A parking lot attendant reviewing a chain of custody. I don't want to put our employees in a difficult situation of attempting to assess. So all I would say is, I think from the executive branch perspective is I would encourage the council to be as specific as it wants to be with regard to what documentation is allowable or not, because I want to be able to give clear guidance to our employees about this is the burden of proof, as it were, that we are going to follow. And I don't, there may be other documents that we may want to amend once we become aware of those other documents, or be as inclusive as we want to be. But I would hate to put the parking lot attendant in a very difficult situation of attempting to assess a second or third degree relationship. Not from I don't think we're concerned so much about the liability perspectives, because hopefully this doesn't happen a ton. We know it has happened. We're hoping it's not a ton. The financial risk is hardly the reason why that we have any concerns about that. But we just want to make sure that we're providing appropriate guidance to families bringing documentation and the attendant who's going to review it and determine the adequacy.
I appreciate that. Yeah, and I appreciate you saying that the liability issue is not the executive branch's main concern here. I would agree with that assessment on balance in terms of what we're likely to see, how much of a problem it could potentially be for the county versus the good that it's going to do for families who are actively facing these difficulties on a very regular basis, and what will be an increasing basis. So I'm going to put that issue aside for now, but would love to hear from more community folks between now and full council, maybe, to see whether it would be worthwhile to think about a chain of custody situation. Because I'll just say that in the course of my work and with constituents, and I know I'm not the only one, that those types of situations where it is maybe the in-law or that sort of thing, I've seen come up enough times that I wonder if it's worth if it's worth considering, if we're able to find a way that operationally, and I agree with you on that operationally it would be something that feels manageable.
Great. And we maybe want to say the same thing, but go ahead, Ms. McCartney-Green.
I just wanted to note subsection D does talk about other documentation
Yes.
as deemed sufficient. So there's a little bit of discretion there. And so not saying everything is included, but there's some discretion there as long as it's consistent with county regulations and what the intent of the law is.
And that's exactly what I was going to say. I appreciate Councilmember Mink. We've been working on this a great deal with members of the community and Ms. McCartney-Green and the county exec's office to kind of find that sweet spot, so to say, of like how to operationalize this and how to find documents that would be sufficient to use. I also want to say that there is latitude built into this, and these are regulations also. So the county executive's office could actually make changes without coming back to us. So once we see this move forward, if, as we have seen, situations do change, it is within the authority of the county exec's office to then also make changes.
Appreciate that.
Great. Councilmember Lukey?
Yeah, I guess I was trying to find an easy way of saying there's the way this is put forth. It allows for folks with the various relationships to one another to show that they have that relationship to one another, but you still also have to show that you are you when you are proving that you are, like if I go to pick up my daughter's car under this scenario, I have the birth certificate to show that I am her mother, but I also still have to show that I am myself with that. And that is still required and nothing's changing about that. Right. Okay. Thank you.
All right. Councilmember Mink? Yeah.
I also, I know the school ID question, I know we've talked about this some, and there are a number of complications with this one as well. I'll just say that the idea of what we should be really affirmatively including and coming to an agreement with the executive branch of what could be included in the what could be included in the regs, what could fall under Section D there, is something that I'm still also thinking through. Obviously, the more we're able to open it up in a way that makes sense operationally and legally for the county, that we can be really clear, that's going to be helpful for folks. But to council staff's point, it's a balance, and finding that right balance is there. But I am interested in further conversations about the ideas that are raised here, about the school ID, about the tax returns. Actually, I'll ask a question. Not going to propose making any changes today, but just noting an interest in further conversation as we move forward to better understand the issue with the tax returns, since that can be classified as a confidential document. Does that make it more of a liability for us because we would not then be able to necessarily go back and use that as proof that we did our due diligence? Or how does that play out exactly in terms of making this not a best practice, or for not a risk test, but for the business entity?
So in drafting legislation, kind of looked at from A to Z. And so worst case scenarios, if there's a complaint that's filed, some of those documentations that was provided upon the release would be used. And so the question is not whether it was a best practice to have IRS tax returns within that possession, or if that was going to be, subpoenaed if there is a challenge. I think the likelihood of a challenge is probably very low, but had to think through all the nuts and bolts of that and thinking about, is there safeguards for towing companies to collect that information and to have and store that? And if there's a complaint, does that individual know that that can be subpoenaed and be used to go through an investigative process? So I know we have our folks here that does the private towing. I think that the process there is a little bit of collecting of that document and kind of working through that.
Okay, got it. So some challenges there in terms of the protections to the individual who would be using that and potentially exposing themselves to having their information be made public, and whether there's protections that could or could not. There's, okay, got it.
And there were some options of redacting that, and that a little bit concerned of, do we want redacted documents to be
right.
given? And so that got into a little
Yeah.
bit of trying to balance that as well.
Got it. Okay.
So I
Thank
think
you.
one of the things that we've been looking at is what, and I really appreciate We Are CASA and all their information, is like what's required at like Department of Motor Vehicles, what documentation. But that is a government, it's a different, as Ms. McCartney Green stated, a different level of government, like it's a government agency asking for documentation and what they're asking for versus a private towing company and what we are providing them and making sure that we're protecting individuals.
Yeah.
So
Yeah. Thank you. It's helpful.
great. All right. I think we're ready to walk through the amendments.
Okay, so we're in the bottom of page 5. It's funny, we've talked about private towing. I want to make sure I kind of explain this part. So this is I will say to you, the executive regulations, just to be very clear, is what promulgates some of the options when it comes to towing fees, recovery, and it's all listed out in regulations. But it's also under Chapter 30C. And so the drafting of this bill kind of shifted under Chapter 30C. But with more discussion and talking it through, honestly, it should be a separate chapter, and it should fall under kind of procedures for police tow. And so without rewriting the whole chapter, I've restructured the language of 1426 to fall under that. And it's very important for the public to know, it's a little bit confusing. A police tow is handled by the Montgomery County Police, and a private tow is handled by Office of Consumer Protection. Is that correct?
Yes, it is. And so from our understanding, what happens with the police tow is there's a police tow list. They have to be registered with our office as a tower. The tow goes to the the tower's private lot for up to 7 days, and then has to be transferred to the police tow lot. So
There's a lot of intermingling. Council staff recommends to separate and create a different chapter. It still fulfills the same goal and doesn't change the purpose of the bill.
Okay, without objection. And I want to really thank Ms. McCartney Green, because when we started on this journey, it was very confusing. And Dr. Stoddard knows this as well, because we've been working on this for a very long time to figure out what is the best way to move forward with this. And I do think, and I really appreciate the Office of Consumer Protection, because it does get confusing very quickly. So I think this is a good move. So without objection, we'll accept that amendment.
Okay. Moving on to page 6, number 4, these are clarifying and technical amendments that were suggested by the Office of County Attorney. Council staff agreed with them. There's really 4 bullet points. I'm happy to talk about it as a block. But essentially, the proof of current registration, the current language had issued by the Maryland Motor Vehicle Administration, but there's some concerns that maybe it's not from Maryland, maybe it's somewhere else. And so to strike that language and just include or current temporary registration. The second bullet point removes the automatic presumption that a person is an authorized agent. Instead, it says an individual who is not the owner but demonstrates that they are authorized by the owner based on the documents that they present. Bullet point number 3, line 55, at least one form of document. I think that's just a technical amendment there. And then the 4th bullet point really refers to the identification clause and referring to using the terminology secured party as opposed to using the word agent there.
Not seeing any questions there. We'll accept all those without objection. All right.
And that completes the amendments for.
Great. All right. Any other comments or questions? All right. Not seeing all those in favor of the bill as amended to recommend to full council, please raise your hand. And that is unanimous of the joint committee. That is all our work today. Again, I want to thank Ms. McCartney Green. This has been a journey. Thank you to Dr. Stoddard, because I know he's been working on this from a while too as well, and I appreciate his dedication on this, and to our Office of Consumer Protection and our We Are CASA. And I do want to do a shout out to Diana Carrillo and my team, who has been working on this issue as well, and thank her for that. So thank you, everyone. We'll recommend this to full council. And with that, we are adjourned.